Okay, we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. We are open today for today's special sitting of one case, Commonwealth v. Bonanno, 2021 P 137. I'm Judge Milkey. With me are my colleagues, Judge Desmond and Judge Lemire, and we are your panel for this case. I want to remind the parties that we have read the briefs and the record, so we're familiar with the basic facts and arguments, and therefore we would urge you to cut to the chase in your arguments. And without further ado, I turn the floor over to Attorney Malinowski.
Thank you, Your Honor. Good morning, Justices. As you know, I represent the appellant Michael Bonanno, and essentially there's no dispute that there was a touching of a bodily part that could be considered indecent under all circumstances, and that the Commonwealth certainly did prove the age of the alleged victim. What we have in controversy is whether there was sufficient evidence presented as to whether that contact was intentional. And I think, as articulated in the cases, these are highly fact-specific inquiries when dealing with such instances. And I think it's important to note that, there was a video that was played for the trial judge that was entered into evidence. And I think there's a tendency to discount the video because that is not necessarily the smoking gun, either inculpating or otherwise the defendant. But what it does show is it sets up the types of things that I've mentioned in my brief, specifically those factors that do not show that this was an intentional touching, but rather one that could have been accidental, and therefore a rational finder of fact could not find beyond a reasonable doubt.
But counsel, you had two eyewitnesses, both of whom testified that the hand was on the victim's breast for an extended period of time. In one case, I believe the testimony said it was over a minute, and the other witness said it was something like 4 minutes. The judge credited that testimony and inferred from that that it was intentional, given the extended period of time. Why isn't that a reasonable inference?
So, and I'm glad Your Honor mentioned that, because the touching alleged by the lifeguard, Mr. Wallace, I believe, said it was up to 5 minutes. And in viewing the video, the subjects are actually in the pool for a total of 20 minutes. So the testimony is that for 1/4 of the time, the touching was taking place. So I don't know how that could be deemed credible. So then we're left with the testimony of the other individual, the supervisor, who indicates that the touching was up to a minute. Well, that doesn't really narrow down the exact length of time.
I think she said at least a minute, but. And in any event, let's say hypothetically the lifeguard overestimated by 50%. It wasn't 4 minutes, it was 2 minutes. That's still a considerable amount of time and consistent with what the other witness said.
It is a considerable amount of time. But when you keep it in the context of the video, there's a constant moving in and around the pool and I counted at least 10 contacts in which the alleged victim is jumping on Mr. Bonanno, whether it's on his front or on his back. So it also goes to exactly how much time was the contact made. And then that also brings me back to the testimony of Mr. Bonanno, in which he indicated it was accidental. So
So,
the intent,
so does that become the issue? I mean, he admits that his hand was on her breast, and he says that it was accidental.
yes.
The witnesses say that it was there a prolonged period of time. I mean, doesn't it become up to the fact finder to, who do you find credible and who do you believe?
I think it is, but I think in this case, what the fact finder disregarded is all the other things that we've seen in the case law, like Cruz and Lehens, that talk about what else is happening at the time to infer intent. I think that's the issue. And in fact, on page 15 of the Commonwealth's brief, they recite the window into the judge's decision on why the judge ruled the way he did. And there was so much inappropriate and irrelevant information before the trial judge. So he specifically said what he disregarded. But my fear in disregarding much of the testimony and the video, as I had indicated, is that there's a lack of the other indicia of intent. So you have on one hand the lifeguards with different timing and not clear on the details, and Mr. Bonanno indicating it was an accident. We're left with looking at the other things surrounding the touching, because we know the touching took place. We're not denying that.
Well, looking at the video, and I agree that the video is somewhat helpful, I suppose, but doesn't illuminate entirely what was going on. But it seems to me a reasonable person might see those two together in a video and conclude that they were more romantically involved than they were father and daughter. Would you dispute that?
No, I wouldn't. And I think that's some of the problem, because I think the supervisor specifically is viewing the parties through that lens, that this is inappropriate. It's not appropriate for a public space. It's not appropriate for, the swimming pool. And that may have triggered the reaction that she had, which is actually consistent with the trial judge in articulating the reasons for the decision. The trial judge talks about, he put much consideration into the reaction at the time of this alleged incident, that the lifeguards and the supervisor kind of formed this huddle and discussed what they had seen and then notified DCF. And it seemed to be that was a real driving force in the judge's decision.
But doesn't the judge in fact say the opposite, that there was a lot, I don't have the language right in front of me, but there was something there, the judge said explicitly that there's a lot here about the inappropriate behavior, too close a relationship. I'm not relying on that. I am relying solely on the testimony of two eyewitnesses who testified clearly about how long they saw the hand on the breast. I credit that testimony, and I infer from the length of time that it was intentional. The pathway that the judge took seems to be fairly clear, isn't it?
It is to that extent, but then the judge did go on to say how he considered their reaction to whatever happened in the pool and essentially being the determining factor, how they had this, the testimony of the two Y employees, their observation that it wasn't incidental. There was this little investigation that occurred on the deck, talking amongst the lifeguards, and the reaction, calling them out of the pool, calling DCF. So I understand the trial judge is certainly in the best position to view credibility, but even within that testimony, there are conflicts, and you have to look elsewhere. And we don't have those other types of things like the court saw in Lehens, when there was a question of when the defendant in that case raised that it was an unintentional contact of a prohibited body part, that the court looked at the circumstances of the touching, of the actions of the defendant leading to the touching, that considered to be intentional. And I guess my point here is that there are no other factors. We have Mr. Bonanno saying it happened, it was an accident. The video could certainly lend to that interpretation that there was so much activity in the pool and so much touching that it certainly could have been an accident, combined with
But let me interrupt you. An accident could be something that was split second, momentarily. Here we have testimony of at least a minute, which if we all just stopped and looked at a clock and watched the second hand sweep around a clock for a minute, that's quite a long period of time that's inadvertent or unintentional. It's the hand is placed in a certain place. I think at one point, wasn't there testimony that the daughter's hand was on top of his hand as well? I mean, so there is circumstances that lead you to believe that it wasn't just a brushing or a, moving around type motion. Lehan's, I mean, I'm very familiar with Lehan's. I authored that decision. It's a case that had a lot more factual facts surrounding the incident, and there was a struggle on a bed that he argued that the touching was part of a struggle. But here we have a clear action of a length of time of anywhere from a minute to 4 minutes of a touching that now is being argued it was inadvertent. Question of fact, is the judge so clearly erroneous from making that question of fact? And if it is, why are you just saying it's because there aren't enough other factors? Is that your basic argument?
Well, I think because in looking at the totality of the circumstances, there's much in the case that militates against the intent if you consider everything else in front of the trial judge. And the direct evidence of intent, if I could say the direct evidence, that would have been the defendant's testimony and the observations of the lifeguards. But then there's everything else that, we're in open space. We have, at least by the count of the lifeguards, 10 people around. People are coming and going. So the likelihood that it was unintentional is more probable than not. And as a result,
in terms of sorting out the probabilities, et cetera, isn't that the job of the fact finder, in this case, the judge? I mean, you're making a very fact-based argument as if we were the fact finder, and of course we are not.
You are not, but under the standard of any rational finder of fact would be convinced beyond a reasonable doubt that the contact was in fact intentional. And I guess that's kind of like a de novo view of the case. Especially when we look at the discrepancies in the testimony of the two witnesses who actually talked about the touching and what they observed. The supervisor could not describe which hand or which breast was involved. Certainly the lifeguard's recitation of up to 4 minutes or 5 minutes, whatever it was, couldn't be consistent with what was plainly on the video. So then we're left with one Y employee and the defendant's testimony, but there are all these other things that are frankly missing that would point to an intentional touching.
Are you saying those things are necessary to find intentional touching? In other words, the testimony of the one lifeguard alone, wouldn't that be sufficient if believed?
I think it's only a factor to be considered in the totality of the case, because that would be, other than Mr. Bonanno's testimony, there is nothing to infer intent, like as if this were another type of case. Other types of cases, we look at all the circumstances, and that's what I'm saying is applicable to this case.
And your best case for that, that we have to consider all these factors, is Lehan's?
Yes.
All right.
And I think by analogy, Cruz, although Cruz talked about the whether something was indecent or not. But I think that same rationale can be transferred to a case such as this when we're talking about whether something was intentional or not.
Do you agree that the longer the touching is prolonged, the stronger the inference of intentional becomes?
I would have to agree with that.
In anything else, counsel? I think we understand the argument.
I appreciate your time. That will conclude my remarks.
Thank you very much. We will now hear from the Commonwealth. For any members of the viewing public, we have, as you will notice, we have a technical issue with the video of ADA Anderson, but I turn now the floor over to her.
Good morning, Your Honors. Audrey Anderson for the Commonwealth, if it pleases the court. The Commonwealth's evidence is sufficient to support the defendant's conviction of indecent assault and battery on a child under the age of 14, where witnesses saw the defendant's hand on the child's breast and where the defendant initially admitted to the police that he touched the child's breast and his hand remained there for a considerable amount of time.
Can I just interrupt you there?
Sure.
The judge appears not to have credited the admission. Aren't we bound by that?
I'm not sure that he didn't credit the admission. He didn't include it in his finding, but I didn't take it that he didn't credit it.
Well, at a minimum, the judge made it clear that he was not relying on that.
He did not rely on it. He definitely said that he was just relying on the testimony of the lifeguard and of the supervisor.
Where he did not expressly credit it and did not rely on it, aren't we precluded from ourselves relying on it, which would seem to me to amount to fact finding?
I'm not sure, but in this case, we don't need it. The judge did specifically say what he credited, and we can go with that. The judge specifically credited the testimony of the lifeguard who said he saw the defendant's hand on Joan's breast for 5 minutes. At this point, he decided Joan, the defendant, needed to come out of the pool, and he contacted his supervisor. The supervisor watched them for 3 to 5 minutes. She saw that they were tangled together, and the defendant's hand was on one of Joan's breasts, and Joan's hand was on top of his hand. And this was going on for more than a minute. She never saw the defendant attempt to remove his hand from her breast or stop her from putting his arms around him. She believed that this behavior was inappropriate for a family environment, such as the YMCA, and reported the incident to DCF. The claim that the setting in which the alleged touching took place was a busy pool, and the defendant seems to say that it was highly unlikely that he would intentionally touch his daughter's breast in this situation. The judge was not required to believe him. He was not required to believe this assertion. The fact finder could readily conclude that it was not implausible for the defendant to place his hands on Joan's breast while in the pool. As to the other factors this defendant claims that are missing, any type of threats, acting surreptitiously at night, these are just additional factors that can be considered the guideposts to help separate conduct that is objectively offensive and sexual from conduct that may be innocent. Any type of discrepancy that the defendant claims between Mrs. Mason and Mr. White, the lifeguard and supervisor's testimony, any inconsistencies That was for the fact finder. That goes to credibility, not to the sufficiency of the evidence. That was for the fact finder to find.
Counsel, you, in your brief, you treat this as a Lattimore case. In fact, this was a jury waived case where the judge made specific findings. So isn't the standard whether the findings are clearly erroneous, not a Lattimore test?
As a sufficiency of the evidence. I'm sorry, could you say that again, Your Honor? I'm
Sure.
sorry.
Normally, as you know, when you have a general verdict by a jury, the court looks to the Lattimore standard in terms of whether or not there was evidence to support that. In the context of a jury waived case where the judge made specific findings, don't we apply a clearly erroneous standard of review?
Okay, this was, I'm sorry, I may be a little confused. I think the defendant requested a required finding of not guilty. I'm sorry, Your Honor, I'm just confused on this point right now.
Okay, well, why don't you move on with what you were going to argue?
There's really not that much more I'm going to argue, because it was the defendant only had really 2 points: that the touching was intentional and that the testimony was inconsistent, and that this inconsistent testimony shouldn't be credible, and that he did not have, that there weren't enough other factors presented to show that he intentionally touched his daughter's breast. The touching, as Your Honor said, of one witness in this case would have been enough to show that the touching was intentional. It wasn't there for a second, as he said, testified that she may have jumped up on me and I touched her breast. No, it was, according to one testimony, 3 to 5 minutes, to another testimony, 5 minutes. And the daughter's hand was even on top of his hand, on top of her breast. This definitely shows intent. Are there any other questions?
Looking at my colleagues, I am seeing none. So is the Commonwealth resting for the remainder of its argument on the brief?
Yes, we are, Your Honor.
Okay, well, thank you very much. This concludes the case. The case is now submitted. We thank both counsel for accommodating us on the Zoom hearing, and we are adjourned.
Thank you very much.
Thank you, Your Honor.
Thank you.